Hi, my name is Sarendra Tyagarajan. My metric number is UDE 240086. My role is Candia Mesita.
Good evening, my name is Chu Kai Wen. My metric number is UDE 240109, and I am here to represent attorney for Derek Palmer against the Amazon.
My name is Khairul Hazwan Ismail bin Marwan. My matrix number is UDE 240094. My role is the defendant lawyer.
Hi, my name is Lo Yong Jun and my metric number is UDE 240107 and my role is the judge.
Hi, my name is Ahmad Jubail and I am from UDE Section 2. My matrix number is UDE 240085. My role is Derek Palmer.
Good morning to Dr. Amina Shashana, my fellow debaters and audience. Today we would like to propose to you that what Amazon did during the COVID-19 pandemic, which involved a serious legal violation and moral codes which lead to deeper investigation. Based on the Malaysian law, which is the Occupational Health and Safety Act 1994, to secure the safety, health and welfare of a person's work against the risk to safety or health arising out of the activities of the person and the work.
Of the court, all rise please.
Court is in session. Please be seated. Defendant, do you have any opening statement?
Yes. Good morning, Your Honor. To begin this trial, I would like to address the central issue of compliance with legal standard during the COVID-19 pandemic. Amazon was operating as an essential business during the pandemic, and we must acknowledge the legal and logistical complexity involved in keeping a company of its size operational while adhering to the rapidly changing public guidelines health. Furthermore, while they were under the challenges during the pandemic, Amazon had taken significant steps to protect its workers. For instance, Amazon provided personal protective equipment, also known as PPE, to all of its employees, installed sanitization stations throughout their facilities, and enforced quarantine leave policies to anyone who showed symptoms of COVID-19. Additionally, Amazon had introduced temperature checks and mandatory mask wearing policy in accordance with the Centers of Disease Control Guidelines, also known as CDC guidelines. The plaintiff argued that Amazon failed to comply with the New York Labor Law Act 200, which mandates a safe working environment. However, it is crucial to understand that the standard during the pandemic was constantly evolving daily. It was nearly impossible to implement every new recommendation perfectly, as there were commitment to its worker safety within the constraint of an unprecedented. It was nearly impossible to implement every new recommendation perfectly as they were issued. Yet, Amazon did its best to adapt to the situation and show genuine commitment to its worker safety and constraint of unprecedented global crisis. To end my statement, Your Honor, I, as part of the Amazon legal team, plead that Amazon is not guilty. That's all.
Are there any objection?
Objection, Your Honor. If Amazon properly checked every company for following new policies, then there should be no oversight inciting such incident happen, and especially of such caliber. What exactly does good faith fit into this situation where not only CDC guidelines were breached, causing the spread of COVID-19 between workers, as well as civilians caught in the crossfire? Where exactly did Amazon adapt to? Amazon's recent action, like giving disciplinary action towards plaintiff Palmer, has violated Occupational Health and Safety Act OSHA Section 18, National Adversary Competing Health and Occupational Health and Safety. The defendant's reason for PPE is immediately invalid, because sanitation stations were proven to be not present during the day where the crime was happening. Amazon's content-sending manner was the reason why everything started, and there is no reasonable excuse for such a conundrum to happen. This also violates Section 5, bracket A, bracket number 1, from OSHA, known as the General Duty Clause. which requires employers to provide a workplace free from recognized hazard they are likely to cause death or serious physical harm. In relation to the previous statement, Amazon has failed to implement countermeasures against the virus as requested by the New York CDC guidelines. They are under the jurisdiction of the OSHA COVID-19 guidelines that Amazon has violated. It is also implied that the plaintiff and their colleague that Amazon discourages taking quarantine leave by not paying them properly and said sanitation stations were not provided as per stated by the New York CDC guidelines. Amazon is also alleged of being a public nuisance. There are two types of harm that contribute to Amazon being a public nuisance, and one of it is physical, where workers who contracted the virus spread it through all the cities, causing harm to society itself. An example of physical harm is where Barbara Chandler, who works for Amazon, contracted the virus and spread it to his family members. One of it who is his cousin, who shortly died in the bathtub later. It is revealed
The
that
virus can be contracted anywhere in the public. Are you sure that the virus contact comes from the JFK8?
but the workers have to work 10 hours, 4 to 5 days in a week in crowded conditions with thousands of workers. That specific harm and direct exposure to the virus that these workers are experiencing. Family members who have taken the virus derived from the exposure
and public session.
Now, plaintiff, please state the compensation law. Now, the plaintiff, please state the compensation law.
Right. About the compensation law located in section 10, page 76, compensation law refers to employees entitled to compensation on the account that there's disabilities and death from injury in the workplace involved. District focuses on the liabilities but does not focus on the context surrounding that liability.
The statute refers to under any liability whatsoever. Doesn't that seem a little bit broad?
But it limits to those entitled to that compensation unable to recover. If you look up the legal and constitutional law history, it is a trade-off to replace the remedy with another remedy, which is what the district law is preventing.
Okay, I heard enough. Now would the plaintiff like to present the witnesses?
Your Honor, I would like to introduce my witnesses. Would you?
Would you please state your name to the court?
Your Honor, my name is Derek Palmer. I am the witness to Amazon's unethical practice at JFK8. I would like Your Honor to prosecute Amazon for creating harsh working conditions during the COVID-19 pandemic. The pandemic that risked the life of not only my colleagues as well as the well-being of the society, and for not providing the necessary compensation for putting them in inhuman working hours. Add to the insult to injury, I was given disciplinary action by the higher ups for warning them about the potential spread of the virus if the working condition did not change. That's all from me, Your Honor.
Your Honor, I would like to introduce my second witness.
Would you please state your name to the court?
My name is Candy Masita. Your Honor, Amazon has been working us like dogs during a time when the virus is running rampant. As an anemic individual, this has put me in danger and worrying about catching the virus, potentially suffering from long-term complications in the long run. This has resulted in contracting the virus unknowingly spread into my father's in his twilight years. He should be enjoying his life, not dying inside hospital. Your Honor, please consider giving us a punishment towards Amazon, as many of our colleagues are risking their life trying to make ends meet. Your Honor.
Court is now in urgent.
Order of the court, all rise again.
I would like to thank all of you for your patience, and I would like to commend Council for the available job that you did. At this point, I will give a detailed review and assessment of all the evidence. However, given the nature of this case, I'm going to brief. Amazon has been accused conducting unethical practice, and Amazon must comply with CDC guidelines, state public health order, and guidance of health professionals. Moreover, Amazon must pay workers for their quarantine leave. Defendant breaching its duty to protect the health and safety of its employee under New York Law Act 200, seeking injunctive relief and declaratory judgment under 28 USC Act 2201. And now, Amazon found guilty.
If the case occurred in Malaysia, the agency that involved in the case in the jurisdiction in Malaysia is a high-profile case like this will fall into the specialist jurisdiction, industrial court to determine the appropriate punishment toward Amazon. Legal framework, as Malaysia is based on the English common law, it will be held in similarity with the United Kingdom law related to business contract. Publicity and impact, a case of such a caliber will attract the Malaysian news media.
The strategy to overcome this case is provide training. For instance, schools can raise awareness to the effect of employee negligence through the subject moral and Islamic subjects. Seek professionals. To avoid the virus breaking out, it is better to consult a professional instead of relying on own surveillance, which is what Amazon doing to cut the costs which unlimitedly bring them down. Early resolution. Identify the problem immediately before things could escalate any further. For instance, provide appropriate pay, less working hours, and make layoffs.